Good evening and welcome back to today's The Hindu Analysis. And today's date is 8th December 2021. So again, I am here to discuss few important articles of today's newspaper. The first one is recently a new bill introduced in the parliament called Mediation Bill Not Getting the Act Together. So we'll try to understand what is called this mediation bill. While it contains many pulses, the bill needs improvement in some crucial places. So let's talk about what is mediation bill and what are the important features. Now, recently, a draft mediation bill 2021 slated for presentation to Parliament bears no resemblance to the original in some crucial places. So, what are the alternative dispute resolution mechanism? So, alternative dispute resolution is a technique to resolve dispute and disagreement between parties by arriving at an amenable statement through negotiation and discussion. So this is called alternative dispute resolution, where suppose two party are in a conflict, they have a conflict of interest, they are in any things where a debate is arise. So there will be some agreement that will be signed, negotiation will be there, and that will be try to solve the problems among these parties. So it is an attempt to establish an alternative mechanism other than the traditional method of dispute resolution. Now, alternative dispute resolution mechanism offers to facilitate the resolution of matters of business issues and other where it has not been possible to initiate any process of negotiation or arrive at a mutually agreeable solutions. So in India, this alternative dispute resolution is established on the basis of Article 14 and Article 29 under the Constitution of India. Now, the directive principle of state policy of equal justice and of free legal aid as engraved in Article 39A of Indian Constitution can also be achieved by the alternative dispute resolution mechanism. So under Article 21 and Article 14, we have a provision for this alternative dispute resolution. Now, what is this called mediation? Mediation, it is a kind of alternative dispute resolution mechanism. Okay, it is like a mediation between the two parties that will solve a common problem, that a common debate between two parties. Okay, so a mediator is involved in assisting the parties in dispute to reach an agreement. The party in dispute themselves set a condition of the settlement to be reached. And the third party does not impose any decision on the party, but merely act as a facilitator involved in improving the dialogue between the parties. What is this draft mediation bill 2021? It recognizes mediation as a profession, which is a huge improvement over the part-time honorarium basis it has in the court annexed mediation schemes. The bill acknowledges the importance of institutes to train mediators and service providers to provide structured mediation under their rules. Now, it provides for pre-litigation mediation. Okay, the bill does away with the confusion emanating from using the both expression mediation and conciliation in different status by opting for the former in accordance with the international practice and defining it widely to include the latter. It also recognizes online dispute resolution also. It provides for enforcement of commercial settlement reached in international mediation with between parties from different countries as part of Singapore Convention on mediation to which India was a notable signatory. The convention assures disputants that their mediation settlement will be enforced without much difficulty across the world, unlike the fresh headache that are in litigative decree or arbitration award presents at the time of enforcement. So it is expected that this bill would make India a hub for international mediation in the commercial disputes field, and indeed institutions are being opened for their purpose. Now, the problem with the draft bill, what are the problem with the draft bill? This problem. So despite the dispute resolution being the judiciary's domain, there is no rule for Chief Justice of India in appointment process. So it distinguishes between India and the international settlement. It unwisely treats India international mediation when conducted in India as a domestic mediation. This distinction is disastrous for foreign parties. Okay, now that is excellent for a case between India parties, but disastrous when one party is a foreign. The reason is that the Singapore Convention does not apply to settlement that already have the status of a judgment or decree. So if you conduct your cross-border mediation in India, you will lost out on the tremendous benefit of worldwide enforceability. In some, go to Singapore or Sri Lanka or anywhere else other than India to conduct your mediation. So none of the member will be active practitioners. Certainly, this bill will be uniquely where a profession is being regulated without a single professional on a regulator. Now, negative list of the mediation also one of the important we can say drawback or challenges. So there is an unnecessary long list of dispute which is should not be mediated, which is not understandable. For example, patents and copyright cases settles on commercial terms, leaving untouched the validity of the grant. So why deny this possibility and consign the parties to litigative longevity? In the case of telecom, why cannot manufacturer and service provider and consumers be allowed to talk on resolved issues? So in case involving minors or persons of unsound mind, the law provides for the court to pass order to protect them. Now the conclusion. So eventually this draft will needs a wider level of discussion and consideration among all stakeholders that will enable a faster resolution of dispute resulting in the restoration of faith of the litigants in the judicial and lawmaking arms of the government. The next important news article is a monumental mistake formed by impunity. So in this case, we'll try to understand the death of 13 civilians by armed forces in Nagaland has brought back the debate on APSPA and controversy surrounding it. So 14 civilians in Mon district of Nagaland, home of the Konyak Nagas, have lost their lives in a firing by para commandos of the Indian Army based in Jorhat. So in the wake of public outrage against the killings, the Nagaland government has urged the center to repeal APSPA from Nagaland. Now, what is APSPA? So it gives power to the army, state and central police forces to shoot, to kill, search houses and destroy any property that is likely to be used by insurgents in area declared as disturbed by the Home Ministry. So APSPA is invoked when a case of militancy or insurgency take place and the territorial integrity of India at risk. Now, security forces can arrest a person without a warrant who has committed or is even about to commit a cognizable offenses, even based on reasonable suspicion. It also provides security forces with legal immunity for their action in disturbed areas. So where is APSPA in effect now? So currently APSPA is in effect in Jammu and Kashmir, Nagaland, Assam, Manipur, excluding the 7 assembly constituencies of Imphal and part of Arunachal Pradesh. The Union Ministry of Home Affairs has recently declared the entire Naga land as a disturbed area for 6 more months till December 31 this year under the APSPA. Okay, so controversies around the APSPA. The APSPA has often been criticized as a draconian act for the unbridled power it gives to the armed forces on the impunity that security personnel enjoy for their action taken under the law. Under the APSPA, the armed forces may shoot to kill or destroy to building on mere suspicion, while the armed forces and the government justify its need in order to combat militancy and insurgency. Okay, and critics have pointed out cases of possible human right violation linked to the act. So once APSPA is implemented, no prosecution shall be instituted except with the previous sanction of the central government in respect of anything done or propounded be done. So Jeevan Reddy Committee formed 2004 had recommended the complete repeal of the law. So how has APSPA been received the people? So in Manipur, APSPA has been withdrawn from the Imphal municipal areas after public agitation and civil society campaign following the atrocious rapes and fake encounter killings. So tragic development may have lasting impact on the ongoing Naga peace process that is not presumed to be in the final stage. It also has the ability to rekindle the narrative of India versus the Naga people. Insurgent organizations might utilize the tragedy to recruit and even enhance their position. Therefore, peace in the region now depends greatly on the Indian state's ability to stay sorry from their heart and not just bargain for just another quid pro quo truce in the present tragedy. The saying sorry could be also be accompanied by a gesture such as declaring APSPA, which has come to be seen as a symbol of oppression across the region abrogated. So this is all for today's news article. We'll meet you tomorrow to discuss tomorrow news article in detail. Thank you.